Thank you all for coming. My name is Rich Acosta. I'm the president of My City is My Home, Mi Ciudad es Mi Casa, a 501c3 nonprofit organization made of licensed professionals here to help out the community in any way we can. So today I'm talking about transfer on death deeds, but we also protest property taxes. We have the largest low barrier apartment map in San Antonio. So if you know anybody that's trying to find housing, you can send them to our website. That website will show you which apartments will work with evictions or criminal history or using a Section 8 voucher. You know, everybody needs a place to live. Well, this is Housing Finder on our website in partnership with sacred.org, which I have their cards and everything on the counter, will help them find their housing. Now, for today, again, this is a educational presentation. I am not a lawyer, so I'm not giving you legal advice, but I am a licensed real estate agent. So if anybody wants to buy or sell a house, just let me know. I'm also a licensed property tax consultant as well, and a licensed general contractor. Mainly, I have those licenses so we can help out our clients and everything. Okay, so first, let's go ahead and get into transfer on death deed workshops. Again, we are a 501c3 nonprofit, so everything I'm providing you is free education. Please share it with people. This only works if you can take this information and share it with your families. Transfer on death deed. So what a transfer on death deed is. A transfer on death deed is a document that you can fill out, and it's going to have your property owner's information on there, information about the property. Then there's going to be a page where you tell them who your beneficiaries, there you go, is going to take over the property upon your passing. So you can have one primary and an alternate, right? And then you take this document after you figure out who those people are going to be, which all you need today is your driver's license. Get this, fill out this form, take it to a notary and have them stamp it with your signature in front of them. You do not need to get any heirs to sign off or let anybody, though we do suggest you let them know there's no need for you to go and get any extra information. For this paperwork, all you need is their name and their mailing address. Then, like I said, you get that paperwork, you take it to a notary, and you get it signed. After you get it signed, you turn it to the county clerk's office. That's when it's turned into the county clerk's office, that means it's legal, it's in the system. You have said that this is what you want to happen to the property that you own, right? That's so it's only finalized when you turn to the county clerk, not after you get it notarized. You get this thing notarized and put it underneath your mattress, it doesn't mean anything. Okay, so anything you do end up doing, please turn it into the county clerk's office. Now, what does that mean is now that this transfer on death deed that has your information, who's going to take over the property, signed and stamped by a notary, turned into the county clerk's office, what happens next? There's nothing. You're done. Now, as soon as you pass away, your family would take your death certificate, take it to the county clerk's office, and they automatically get the property. They don't have to wait for probate. And so that's what a will is. So a will is for those of you that put down all the different things you want. How do you want your remains to go? Where do you want your jewelry to go? You can be very, very detailed on a will and exactly how you want your wishes and everything. And you can have that will put into the county clerk's office as well. But the transfer on death deed is the thing that takes automatic, because a will, the county clerk's office isn't going to read the will legally for you. The family member has to take the will and have it go through probate court. So that's going to be a whole nother day. Maybe some attorneys need to be hired for that. But the transfer on death deed, as soon as that death certificate's turned in, whoever's on the transfer on death deed gets the property. If somebody else is on the will, sorry, that person's not going to get the house. It's whoever's on the transfer on death deed. That takes precedence because it automatically got activated when that death certificate was turned in. Okay, so that's how that works. I also get questions about the transfer on death deed on what's the difference between a ladybird deed. a ladybird deed is very similar to this, except this can be done without an attorney, right? And the reason why you still should contact and talk to an attorney, but the reason why you can do this form without having an attorney review it and everything, because all you're doing is giving away that asset and that's it. The ladybird deed, you can put down more information. You can put down, all right, you're getting the house, but he's paying the mortgage and she's going to pay the liens. And there's more things that you can differentiate on a ladybird deed. But if you're thinking to your head that upon my passing, he's going to get everything, that property and the liabilities that come with it, here's the transfer on death deed, done. You're going to get the property once they turn the death certificate. So if I could simply put it, transfer on death deed, quick and easy, just for that property. Ladybird deed, okay, I need a lawyer because there's a couple of things about my property on how I want things taken care of to be done. A will, very detailed. You can put down exactly how you want things, but that has to go through probate court. The ladybird deed and transfer on death deed take effect as soon as the death certificate's turned in. That's the main difference. There's also a trust. People are familiar with trust, and that's when you actually have a trust agent that monitors the property, and different people can live into the property, and it doesn't have to be on your ownership, right? It's owned by the family trust, and there's a lot more detail to that. That involves hiring an attorney, getting that all done. I'm not going to go into the details of how to set up a trust today, but that's what you hear a lot of people. It's like, oh, that's really what you can do to protect your assets. That's true. It is a great way to protect your assets if you plan on having to allow different people live and get that homestead exemption for the property. Because let's say I live in that property right now, part of the family trust, I can live there and get my homestead exemption. Well, I'm moving out and my sister's going to be moving in. As soon as she shows that she is now, that's her primary residence, she can now get her homestead exemption on there. And that didn't have to do with changing the ownerships, because it's all owned by that family trust. So that's a little more complicated than what we're talking about. We're talking about the bare basics today. If all you want to do is set up a process so upon your passing, the house, the most expensive asset that you own, transfers to your heir, that is what we're discussing today. So how to fill it out? Very simple. Like I said, you put the owner's name, the owner's mailing address. And this is because you might have more than one property, and every property you own, you can do a transfer on death deed for. So the primary owner, if you got two owners or multiple owners on this, then yeah, you would put the additional owners as well. The mailing address, your legal description that you can find on your deed. And if you need help figuring that out, we can also look on the county clerk's records to find your deed. And so it can have the legal words in there. Let's see. And then, oh yeah, here it is. Bexar County, Texas Public Search. But just look up the county clerk's office. Then you actually put the address. That's going to be the property that you're going to be passing over. Then you're going to have three different ways to pass the property over, or different scenarios. The first scenario is A, which is somebody that's you guys are married and you both own the property and both of your name is on the property, but you still need to get a transfer on death deed done. Because what if I had a stepson from a different marriage? Well, my 50% is still, there's still an heir to my, and they could challenge that. So what this is doing is getting rid of all challenges. I don't want, when I pass away, I don't want my spouse have to worry about or fight about any ownership of the property. It is going to be theirs and the world is going to know it, right? So that's what A does. It's a form. We put it in that you guys are both agreeing that the spouse is going to get the property, and then you put down who your additional heir is going to be. So if both of you were to pass away, this is where the property would go. B is if you're married and the spouse isn't on the deed. Well, all right, let's go ahead and correct that real quick. We'll put down on B, my spouse is this person's name, and they're going to get the property on my passing, and this is the additional heir if we both were to pass who would get the property, right? And then C is for if there isn't anybody else on the deed and you're just going to be passing your portion of ownership. What if there's 5 different owners? That's okay. If you're only doing this form for your ownership portion of your ownership because you're having it with like a couple of uncles and aunts or whatever, well, again, you can do this form just to pass your portion of ownership. So if you own 25%, you can pass that ownership. Or if you don't have a spouse, well, then you're passing the 100% ownership to your heirs. And then the other thing that you'll be able to do, which I believe is this next slide. Yep. So you put in your primary beneficiaries, just their name and mailing address. You can also put the secondary or your alternate beneficiary. And again, that is somebody, let me put it into the scenario. John, my son, is my primary beneficiary. And then I choose my cousin as my alternate beneficiary. So if John were to pass before I were to pass, I don't have to redo this form because I still want my cousin to be an alternate beneficiary. So she could still get the property if John were to pass before I did, and then my cousin would be able to take onto the property. Now, if I did a different way where I put alternate beneficiary and secondary alternate beneficiary, that means that if you put both people on there, that means they get the property 50-50, right? And so that means that they would have to make a decision on selling the property or anything together. Now, I'm not a lawyer. I'm not giving you legal advice, but if you have multiple heirs, we suggest, and we've heard, that the best approach is to put one person that you feel is the most responsible. So that way heirs are not fighting over the property later on. You have your will telling everybody what you want done, and then you left the property in the name of one of the siblings because you trusted that they would respect your wishes the most, right? And that just gets away with, years later, people are fighting on who gets the property. It's like, nope, mom said that I was going to be in charge on what's going to happen, and this is what we're going to be doing. That's just something you can do, but you can put additional beneficiaries. It's just they're all getting a little bit of chunk of the property, and so that later on decides on who's making those decisions later. The other thing that you'll be able to do is if John, my son, and he was my primary and my cousin was the alternate, if my son had kids, what I could do is have it set that the deceased will share the past to their surviving children. So that means John would have been able to pass this to his kids before it went to my cousin that was the alternate beneficiary, right? So I'm saying here, I want my son's kids to have a chance to get the property. And if they maybe they don't even exist, he didn't even have kids yet, right? So he doesn't have kids. Don't worry about it. Goes to the alternate, my cousin, in that idea. Or you can say no one's going to get this. It's not going to go to the kids, the grandkids, or anything. I want to handle differently. And that's again why wills are not. I'm not saying not to have a will. This helps pass the property quicker and lets everybody know what your wishes through the will is a process that you can take. All right, and then the last page. So review real quick. We just put down that you're the owner, your mailing address, the legal description, and the physical address that you're actually passing. You put down who your primary heir is going to be, and then you put an alternate heir. And then you're going to take this form to a notary. You're not going to sign this page yet until you're in front of them. And you just bring your driver's license that has your address on there, and the notary will sign off on this paperwork, stamp it, and you can take this to the county clerk's office, which we have in the front. The county clerk is located downtown at the court office, where you would have to pay for parking, but they have a records on the run. What records on the run is, is at each precinct, they'll have like this bus that will go to different areas, and that way you can turn in your documents there. Like for instance, they have it here sometimes. They also, excuse me, they also have them at the Madonna Center. They often have them over there. If you guys know where the Madonna Senior Center is, so once a month at each precinct in Bexar County, records on the run will be, so you can turn in important documents because they do more than just take in transfer on death deeds. So it needs to be notarized and recorded for it to take effect. This takes precedence over a will. So again, if somebody's on the will but somebody else is on the TODD, whoever's on the TODD is going to get the property. You can change this, right? You decide that you don't want John to get the property anymore. You want somebody else to get it. Well, you can cancel the transfer on death deed and put in a new one. All just filing this with the county clerk's office. The property can still be claimed by creditors. So I hear about this when it comes to what if my family member was in a hospice or Medicare, Medi-Cal, I forgot which one is the one that affects you. But as long as they didn't also do a transfer on death deed. But if you've already taken care of this, they can't override yours. Let me step back. So at a hospice, they could say that you don't have to pay anything. All right, we're going to take it from your assets upon your passing. And they could have your family member fill out a transfer on death deed, making that upon their passing, the hospital automatically gets the property. If they don't do something like that, then more than likely they're going to be putting a lien. But again, if they just did a lien, you own the property. So whoever you pass the property to through that transfer on death deed, they still own it. They'll still have to worry about the liens on the property that you put the bills against, but they still own it. And if somebody were to put another transfer on death deed, unless there's a cancellation, you can't put a transfer on death deed on top of another one. It's the first one that takes precedence. And if they need to cancel it, then they have to go through that process. So, again, if the hospice or anything like that were to force a family member or to ask a family member to sign a transfer on death deed so they can have their assets go to them, well, if you've already have this transfer on death deed in place, then that's not something that they could do because this one has to be canceled first. Other homeowners resources we want to share with you is through Vanguard. The county clerk's office has this deed alert program for just like the situation I just told you. What if somebody else gets a fraudulent transfer on death deed or tries to do something fraudulent to my deed? There's a lot of fraud going on, right? Well, if you get on this deed alert, the county clerk's office will let you know when something changes into the system without you knowing, right? Or if you turn into this transfer on death deed, they'll let you know, hey, by the way, somebody turned in a transfer on death deed. It's like, I know that was me, but those are the types of alerts that you'll get that are all tied to your property. Somebody puts a lien or something like that, and they put it in the county clerk's records. That's like how mechanics liens and stuff like that. How like when you sell a property, how are they going to know? The title company. When you sell a property, the title company will do a title search to see if there's any liens, any issues with the property. And a lot of that stuff is uploaded in the county clerks, and that you would have known about it if you had those deed alerts. And that's something free that you can get set up. There's the city of San Antonio has homeownership repair programs. So keep an eye out for those. Those are often open up quarterly. So you might want to look at October, keep up with the city to see any new home repair programs are coming out. They usually always have the under one roof program, but they kind of distribute it depending on what districts you're in. So my advice to you is to apply and get with your your district council members that could give you an update, because they'll just put you in their little mail chain and send you updates as they go along. Let's see. Make sure you apply for your property tax exemptions. So your homestead exemptions, your senior free. So the different homestead exemptions that are out there is everybody that owns a property can get a homestead exemption. If you own that property and you live in that property, you can get your homestead exemption. Doesn't matter what your age is. You own the property, you can live in that property. Then the other exemptions is the senior freeze. When you turn the age of 65, the majority of your taxes are frozen except the River Authority and uh, Universal Health System and River Authority. Let's see. Then if you're a 100% disabled veteran, of course, you can get an exemption there as well. But all these you have to apply for. So if you're a senior, make sure that you don't have to wait until your birthday, but as soon as that year that you turn 65, you need to let the county know that you've turned 65, and then they'll get your freeze in there. When you pass away and you turn that death certificate, that is the same type of stuff as how that changes on the deed for your appraisal district and everything, how you change those names. Is just giving the appraisal district the death certificate, and they'll update the names and everything. Know your resale value. So I know most of you are here for homeownership preservation, but if you know anybody that's a investor or somebody that's come knocking on a door, make sure that you talk to a real estate agent to get that full value of your home. You know, don't even rely on the county appraisal district to tell you what the value is on your home, because as a real estate agent, it doesn't matter what that value is that the county says it is. I have a whole organization dedicated to protesting property taxes. So over 85% of the time, those valuations are wrong. And the reason why they're wrong is because they don't know what the condition of your property is. If you've remodeled it or if you haven't remodeled it, they're basing off of sales in your area, and they're saying that, well, these homes have sold recently for this amount of money. If your home is in the same condition as theirs, yours should be the similar value. And if that's not true, you got to tell them every single year. It's fun protesting property taxes, right? Homeowners insurance. As your valuation raises, right? You need to let your homeowners insurance know that you're keeping your property taxes values and everything lower, because if they might not know, they might be relying just on the county appraisal district to get those valuations. That can help you keep your insurance low as well, making sure they have the right valuation. And always use a licensed professional, whenever you're doing your stuff. And again, I'm not an attorney, but we have our good friend Rudy Vasquez that is an attorney. So if you have any legal questions after today's presentation, after we help you with the forms and everything, we have some of his cards up there, so you guys can reach out to Rudy Vasquez and set up an appointment and talk to him. Ask some more questions. But in San Antonio, the south and west side are notorious for not having good estate planning. There's hundreds, if not thousands, of properties that can't be sold, even though the family would like to, because the estate's all messed up.